Social media has become the new digital forum and place for ideas. What happened when Texas A&M blocked PETA from posting on the university's Facebook page? Learn how PETA's victory means your First Amendment rights can also work for the animals. Next on the PETA Podcast. Welcome to the PETA Podcast. I'm Emil Guillermo, your host for this behind-the-scenes look at PETA, the largest animal rights organization in the world. And welcome again to another program. PETA's been fighting the Texas A&M dog lab case for years, but in 2018 it discovered Texas A&M was censoring PETA's views on the university's official Facebook page. It was a filtering process that amounted to viewpoint discrimination, and it's a violation of the First Amendment. PETA sued the university, and this week got the university to stop the blocks on comments on the page and to pay PETA $75,000 in legal fees. In a digital age where millions of people are online, it's a groundbreaking victory that sets a precedent when it comes to a governmental entity and its use of social media like Facebook. You can't just immediately dismiss the First Amendment rights of anyone who posts, including animal rights activists and the message they carry on behalf of the animals themselves. What animal rights activists should know about their First Amendment rights in this digital age, and how PETA figured out how it was being censored. My conversation with PETA's attorney, Gabe Walters, on the PETA Podcast.
This is a hugely important case. This is one of the first cases in the nation to seek to apply the First Amendment to a social media account run by a government agency. So there have been a handful of other cases, most famously involving President Trump's Twitter account. He got in trouble with the courts for banning critics from his Twitter page. And there's been a case in right here where I'm based in Virginia involving a public official who I think she was a county board of supervisors member who blocked somebody from posting information about other council members that she considered slanderous from her own Facebook page. And then there's this one, which ended, of course, not with a judgment from a court, but with a settlement that was in our favor. This is one of the very early cases testing the applicability of the First Amendment to government officials online and especially on social media.
And that's a critical thing, because if it's just me and you, private citizens, even people who are public, we're private citizens, we're on social media, the First Amendment doesn't necessarily apply in terms of if you're trying to use it to go to sue someone. But the difference is if you're dealing with a public entity, a government entity that gets taxpayer money, now suddenly the First Amendment is your friend, right?
That's exactly right. In constitutional law, we have what's called the state action doctrine. So if I'm Walmart, for example, or any other private company, or even just a private individual, I don't have to put up with critics of my policies or practices or what have you, because I'm entirely private. But if I'm a government actor, the Constitution applies to me, and I can't shut down critics from my page simply because I don't like what they have to say about me. And that's exactly what Texas A&M University did here. But in terms of social media generally and the importance of the First Amendment and free speech in the social media space, I think that the recently retired Justice Kennedy of the Supreme Court said it best in one of the very early cases looking at what social media is in relation to the First Amendment. And he said, and I'm quoting, "While in the past there may have been difficulty in identifying the most important places in a spatial sense for the exchange of views, today the answer is clear. It is cyberspace, the vast democratic forums of the internet in general, and social media in particular. He's quoting a case that the American Civil Liberties Union brought in 1997 against the then Attorney General Janet Reno, but he's adding the social media bent because social media didn't really exist in 1997, right, though the internet was growing in popularity at the time.
And so now we have a situation where free speech, you have your right to free speech, but it's a different thing when we're dealing with the government in these spaces. And when they do something that you have fought for, fought against, which is viewpoint discrimination. What is viewpoint discrimination in this case? And we're talking about the Texas A&M University handling of their Facebook account and how they discriminated against the views that PETA members or PETA supporters had on that Facebook page of Texas A&M.
I think the simplest way to boil down what viewpoint discrimination is to say you allow speech that you like, you disallow speech that you don't like, you block your critics. And that's exactly what Texas A&M University was doing here. So just to give you a little bit of background, if I can, on the dog laboratory, since 2016, PETA has had a really active, pretty massive campaign against Texas A&M University. I'm sure you and many of your listeners know all about it. Yeah. We've written to public officials, we've staged demonstrations, we've leafleted the campus, we've had phone banking campaigns. Bill Maher and I believe Lily Tomlin have been involved. There's been celebrity involvement because Texas A&M is experimenting on dogs, primarily golden retrievers, to breed them to have a condition, a canine form of Duchenne muscular dystrophy. And we have some footage and some photographs from inside the laboratory, and these dogs just are in a very sorry state. I mean, they're standing on slatted floors, they're fed this kind of gruel. They just look horribly sorry for dogs. Body condition score looks to be particularly low. And this has really resonated with people across the country who naturally love dogs. So we've had a lot of great participation by our supporters and our members. And Texas A&M, of course, has fought back at every step of the way and given the public a lot of misleading information about what they're actually doing, including, for a time, denying that they were breeding the dogs, selecting for this genetic condition to be born with the disease. Until finally, near the end of 2019, they essentially admitted that they had been doing it when they agreed to stop breeding the animals at A&M, which, of course, PETA declared as a great victory coming out of this years-long campaign.
But they're still doing some experiments. They're just not breeding, right?
That's correct. And, of course, PETA's campaign will continue until Texas A&M University shuts down the dog lab, which is what we have long demanded and what we continue to demand, and we simply will not stop until they no longer engage in these cruel practices toward these dogs.
All right. So Texas A&M went on a Facebook page, and it posts their view about all this. And back in May of 2018, PETA supporters responded to what Texas A&M put on its Facebook page, and they blocked or they deleted or filtered some of the comments. Is that a description of what happened?
You've got the gist of it. There are a few different ways that PETA and its supporters have put content to appear on Texas A&M's Facebook page, which of course we're alleging is a public forum, right? Mm-hmm. So one is that PETA can tag the university in PETA's own Facebook posts, and that will automatically put those comments on Texas A&M's page in the visitor posts section. Another way is to leave comments, as you say, on Texas A&M's own posts. Whether they talk about the dog lab or whether they talk about really any other subject, the comments section is what's called one of the interactive spaces of the Facebook page. That's the term, interactive spaces, that you see in these court decisions dealing with this subject that I mentioned earlier. And so what they've done is simply deleted comments, and they've untagged themselves from PETA's visitor posts. And they've done it in two different ways. The first way is that they've set up an automatic word filter. Mm-hmm. So they've gone into their settings, and they've decided that any comments that you attempt to post that include the words PETA, lab, abuse, cruel, cruelty, and even MD for muscular dystrophy will simply not appear. And it's actually clever the way the software does this, because to you sitting at your computer making the comment, it looks like the comment does appear, right, but it won't appear to any other user viewing that thread, that comments section. So we had multiple people on the phone with each other testing various words and combinations of words, saying, okay, I posted it, can you see it? And the person on the other end of the line says, no, it's not showing. And that's basically the story of how we figured out that there are certain words that would be allowed to appear and certain words that wouldn't. And the second way that they were deleting content is that if somehow a user of the Facebook page was able to beat the filter and get content posted, they would go in manually and delete that content.
And people who are listening, who are Facebook mavens, they know everything about Facebook, they're internet marketers, this is kind of standard. I mean, I think the unusual thing is that we're dealing with a government entity or a government sponsored institution that is on this medium, and they're doing it to really curtail First Amendment rights that are afforded to people who come on this forum. And so is there ignorance? Well, they did it deliberately, but they could claim ignorance. Who really has a responsibility here? Is it Facebook? I mean, because this tool is available to everyone. If we were private citizens, we can block each other. We can filter each other.
I fully understand that sense of skepticism in the background that some of your listeners might have and that you've just expressed. I once had that sense of skepticism myself until I started digging into the case law and the arguments here. And the theory of the case really is, this is a public forum no different than the town square. It just happens to be online. Mm-hmm. It's set up by government for the purpose of having a back and forth conversation with Facebook users. That's what the comment section is for. That's what the visitors posts section is for. And the government doesn't need to open that forum, right? If a university or other public agency wants to use Facebook, they can do it without turning on the comment section. They can do it without turning on the visitor posts section or any other space where interactive back and forth communication might occur. But if they do open those spaces, they have opened a public forum, and the First Amendment applies to those spaces just the same as it applies to the park-like campus in College Station. It's really no different than the streets and the sidewalks where people might gather or leaflet or exchange views. And so once you've opened that space, you cannot discriminate against users on the basis of their viewpoint. If you do, you have axiomatically violated the First Amendment. That's what this case is about. That's what the Trump case was about. That's what the Virginia case was about. Every case so far is coming out this way. But I think one crazy exception in Kentucky involving former Governor Matt Bevin, there was a district court case that went the other way. But what Texas A&M is saying is, hey, this is technology, this is social media, this is new, and this is complex. If you saw the recent Associated Press story announcing PETA's victory with the settlement agreement, they said that they hope that their settlement can be a guide to other universities to figure out the complexities of social media and the First Amendment.
Well, in some ways, this is new ground, and they probably could claim a certain level of ignorance, although they knew what they were doing. They were shutting debate. And they should have known, I'm shutting debate. This is a violation of someone's First Amendment rights. But, I'm sure they could claim, okay, this is a new thing. No harm, no foul. But and therefore there's a settlement. There's no precedent set by this settlement, or is there?
It's new ground and it's not new ground. I'll take that point first, and then I'll talk about the precedent. So it's new ground in the sense that this is, as I said earlier, one of the early cases involving the application of the First Amendment to government social media pages. Yes, that's right. It's not new ground in the sense that the legal doctrine involving public forums is extraordinarily well established. This goes back to I'd say the early mid 20th century, right? We're talking 1920s, 1930s, where if you have public streets, public sidewalks, that's called a traditional public forum, and the government may not engage in viewpoint discrimination, may not engage in content discrimination unless it has a very good reason for doing so, and the means it exercises are the least restrictive necessary to achieve its ends, whatever those legitimate policy ends might be. And then you have what's called a designated public forum, where the government intentionally opens up a non-traditional public forum for purposes of expression. And that's exactly what a Facebook page is if it has those interactive sections like the comments section. The third type is a limited public forum where the government might say, well, this is for this type of speech. This is for this category of speakers, or this is for this subject matter, right? Even in that third category, you cannot engage in viewpoint discrimination. Now, the limits that Texas A&M has set on this Facebook page in the comment section are none. Anyone can go. Anyone can talk about anything. You don't have to be a student. You don't have to be an alumni. And the reason we know that is not only because we used it, but because we got their Facebook settings through a public records request. And that's where we were able to confirm some of the words that they had set in their automatic filters. But we also confirmed that the page is wide open to everybody on any topic. It's not limited in any sense.
What does this establish now that they've settled with PETA? PETA's gotten them their settlement. I presume does not come with any admission of guilt, right? Or tell me.
So this did end in a settlement agreement out of court. The court retains jurisdiction to enforce the terms of the settlement agreement, which I can lay out in a second. It doesn't come with a consent judgment, meaning there's no signature by the judge on the settlement agreement itself. And you're right, they've admitted no wrongdoing. However, they did move to dismiss this case on the theory that we hadn't stated a claim because supposedly the First Amendment doesn't apply here. The judge denied their motion to dismiss. So that decision is precedential for what it's worth, right? We didn't get to what's called summary judgment, where each side makes their case and the judge, as long as there are no competing issues of fact, the judge decides the case as a matter of law. We didn't get to that stage. We did file our motion for summary judgment. And at that point, the university started engaging in these settlement discussions.
But any university looking at this will know that they better either close discussion and not have discussion, or open it up totally and not discriminate against viewpoint and not censor, right?
Exactly right. This is one of the early cases that should serve as a warning, as a shot across the bow to any and every public university, any and every government official, any elected politician, that if you have a social media account that allows people to come and comment, you can't block people because you don't like what they have to say. You can't delete their comments because you don't like what they have to say.
But if you didn't have it open in the first place, you can avoid the problem totally, but it wouldn't be a forum. It would just be a one-way forum.
That's right. So if you want to use Facebook merely as a one-way street, right? Merely to disseminate information, say, to constituents, or if you're a police department, if you want to give out, street closings or public safety information, you can do that. But if you open that comment section, or if you leave it open by default, you've created a public forum, and every public official, every agency should know that and act accordingly, because the Constitution applies. And if you engage in viewpoint discrimination, if you silence your critics, you have violated the Constitution.
And people or institutions will be sued by savvy activists who know their First Amendment rights.
That is exactly right. And there are First Amendment lawyers like me and like our counsel from the Electronic Frontier Foundation in this case, who are looking at this issue and finding all sorts of places to bring these suits, because this problem, unfortunately, is rampant. But maybe after victories like this one, it will become less so.
Yeah, you got to figure that because the internet is relatively new, Facebook, just within the last, 2007, 2008, it's exploded and everyone's using it. I'm sure some people are saying, let's just put it out on Facebook. It's, for some people, it is the internet. And they don't know the fine points of the law or the First Amendment or the Constitution. But if you shut down, as a private, the confusion comes in when you're a private citizen. If you shut things down, it's okay. As a private citizen, you can do that. But if you're representing a government entity or a public official or whatever, now you're on totally different ground. And if you open it up, you got to keep it open for that First Amendment.
Not only that, but public universities especially are well represented by counsel. In this case, A&M was represented by the Texas Attorney General's office. Many public universities have their own in-house counsel with offices right on campus. So general counsel or attorneys general should be following this news, should be advising their clients accordingly. This is not actually hard stuff. It's new, but it's not hard. The same law that applies to the sidewalks on your public campus apply to your school's Facebook and Twitter accounts and whatever other social media accounts you might have that have those interactive spaces that allow commenting and two-way communication.
In some ways, this is what happens when people who are communicators say, well, let's go to where the people are. They're on Twitter, they're on Facebook, let's go there. Do you think they're being totally just sort of lax or were they ignorant, or were they being really hostile here by cutting off the views that they didn't agree with?
In this case, I think it's probably more hostility than ignorance or laxity, right? Primarily because PETA has had this multi-years long campaign trying to shut down the dog lab at Texas A&M. But there probably are some actors out there who just don't know. And with news like this settlement and some of the other cases I mentioned coming to the forefront, there's not going to be any excuse for not knowing. And especially if you violate somebody's constitutional rights, as a public agency, there's not going to be any excuse for not knowing. You are exposing your institution to liability. And as I said, counsel should be advising accordingly.
And what does this do to the campaign to stop the dog labs at Texas A&M? How does it bolster PETA's efforts to end the madness there at Texas A&M and the dog labs?
This pries open one more forum for us to make our campaign heard by Texas A&M. This is another opportunity for us to spread our message and awareness of our message, not only to Texas A&M officials, but also to its alumni, to its student body, to really go direct to where people are and to build support for this mass movement to shut down the dog lab.
Gabe, I really appreciate your time and explaining this. The legal First Amendment constitutional nerds, the same people who are watching every single minute of the impeachment trial, they will be glued to your every word.
I hope so. And thank you so much for the opportunity to speak with you today and to get the word out about this settlement agreement. And by the way, we haven't mentioned that Texas A&M has paid $75,000 in PETA's and the Electronic Frontier Foundation's legal fees. So we should get that out too, because that's another reason why Council for Universities should be watching this news very carefully, because they're not only incurring constitutional liability, they're going to be costing their clients money if they don't advise what their duties are in these social media spaces under the First Amendment.
And that's an excellent point, because they don't, some people, if I didn't mention that, or if you didn't mention that, some people say, oh, the university, what's it cost them, right? They've got these attorneys on hire anyway, and, it's just, some legal time. But there was a real penalty. Those legal fees really add up. They're significant, and they're now helping the cause to stop the madness at Texas A&M. So, Gabe, thank you very much for your time.
Thank you, too.
Yeah, really appreciate that. It's important. The First Amendment. All activists need to know how the extent of the First Amendment, to protect themselves and to make sure that their speech is heard and protected.
The First Amendment is a very powerful tool in every activist's playbook, and it should be used just as strongly as it can be.
Gabe Walters, PETA attorney on the precedent-setting First Amendment victory for the animals and PETA, a settlement with Texas A&M. It's still testing on dogs, but now it can't block PETA's voices from speaking up for the animals. Go to PETA.org for more information. And that's our program. Hey, you can contact us at PETA.org. You can find me on Twitter at Emil Amok, or on ALDEF, AALDEF.org/blog, or on my website, amok.com. I'm doing my new one-man show. It's called Emil Amok, Married to PETA and Other Love Stories. It's my own animal kingdom journey in San Francisco's Potrero stage for February 6th, one more day, and then who knows? Hey, I'll come to your town, your living room, your church basement somewhere. Just contact me. It's my Spalding Gray invitation where I ask, can a pig-eating Filipino dude find his way to veganism in his rightful place among the animals? Go to amok.com for details. Once again, thank you for listening. Check out all our episodes on Apple Podcasts, where you can rate and review the show. It helps get the word out about the issues you care about. Our music provided by CarbonWorks. Check them out on YouTube. And join us again next time for more insight into animal rights and the fight for a cruelty-free world on the PETA Podcast. I'm Emil Guillermo.